Back on the record, I would move or entertain a motion that we come out of executive session.
So moved.
Second.
All in favor?
Aye.
We are out of executive session. By the way, for the record, I think we went into executive session at about 4:03. 4:03, thank you. And we are coming out of executive session at 4:18 p.m. The matter before us, again, as we have indicated initially, is the appointment of legal counsel to represent the Board of Elections, the Stark County Board of Elections, in the pending matter. I don't have the caption in front of me, but it's the pending matter that I just referred to as the Maier writ of prohibition case. I have several comments on it, and I'm going to make a motion in this, and we will see where that motion goes, and we will take it from there. We are faced today with the need to decide on the appointment of legal counsel for the Board of Elections in the George Maier writ of prohibition case. The Board of Elections statutory counsel is the Stark County prosecutor. However, in this case, Prosecutor Ferrero has advised his board of his conflict in the case, and as a result, he and his entire staff are disqualified from representing the Board of Elections. It is therefore this board's obligation to recommend counsel to the Common Pleas Court for appointment. The matter is of very serious import. Its importance is emphasized by the many front-page stories in our county's newspapers, and to include Mr. Olson's many political blogs concerning the qualifications of Sheriff Maier, and also the multiplicity of lawsuits that have occurred in this matter to date. Because of the importance of this, I believe that it is our obligation to appoint very experienced and competent counsel in the area of elections law. I will be, at the conclusion of this, making a motion and recommending the appointment of the law firm of McTeague, is it McTeague or McTeague? McTeague and McGinnis LLC and Donald J. McTeague. It's good afternoon to represent the BOE in this case. Mr. McTeague is uniquely qualified, and I'm looking at a list of his qualifications, referred to as the gold standard in election law by a federal judge. He has concentrated in the field of election and campaign finance laws for 3 decades, formerly Chief Elections Counsel to the Ohio Secretary of State, former counsel to the Ohio Elections Commission. He has represented clients in numerous election-related cases before the Ohio Supreme Court and the Ohio Elections Commission. He is also an adjunct professor of law at Capital University Law School, where he has taught elections law. Mr. McTeague has stated his willingness to represent the BOE in this case for a capped fee of $8,000. In the world of legal fees, particularly given Mr. McTeague's eminent qualifications, this is inexpensive. I recognize also that $8,000 is $8,000. I also recognize and deeply respect this board's commitment, and I am a participant in that commitment, to not spending any additional taxpayer funds for lawyers in this case. I respect the desires of our taxpayers that we do not spend public funds on this and similar matters. However, in this particular case, it is one not of our own making, nor is the conflict that's been created one of our own making. We must appoint someone, and I feel that we have an obligation to make that appointment to the best of our ability. We have discussed the appointment of David Bridenstine, who works as an attorney in the Commissioner's office at no apparent cost to the taxpayers, if he were to represent the Board of Elections in this case. First, I would comment that I don't think that that is totally accurate. There is a cost. The attention of Mr. Bridenstine's time and effort on this case, which I would estimate will probably be in the range of 50 to 100 hours, is time and expense which won't be spent on matters for which he was hired. Second, and this is probably more important to me, there are and will be allegations made challenging his independence, given his 30-plus years of former employment in the prosecutor's office, many of which were under Prosecutor Ferrero, and given the additional fact that he works daily with other assistant prosecutors in Mr. Ferrero's office. And if he loses this case, I am concerned that there will be allegations that he didn't try hard enough, that he prejudged the case, or that he wasn't experienced in election cases. David Bridenstine, and I really want to emphasize this, has an excellent reputation as a lawyer. That's why we hired him, and that's why we want to keep him here. I have the highest confidence in David Bridenstine and in his abilities, and particularly in his integrity, and I would not hesitate to hire David Bridenstine to represent me in any particular matter. Perhaps not in my divorce. But given all of that, I don't think really that David can be disentangled from the above concerns and the allegations of which may flow. These are the type of allegations, by the way, which normally don't exist in any attorney's representation of a client, and in particular in an attorney's representation of a client in a public law case. I mean, hey, lawyers win and lose cases, and they get beat up to some extent, but they seldom get beat up for reasons of conflicts and other allegations and so forth. And without denigrating his legal abilities, again, which I fully respect and admire, I mean, it is clear to me that his experience in elections law representation is significantly smaller than Mr. McTeague's. All in all, my bottom line with regard to this is that I simply respect David Bridenstine too much to throw him into this mess. Given all of that, sorry, this is one of the longest motions in history.
Okay.
Given all of that, I move for the appointment of the law firm of McTeague or McTighe, I keep saying it wrong, and McGinnis LLC and Donald J. McTighe, its principal, to represent the Board of Elections in this case for a capped fee of $8,000. That is the motion, and of course that motion requires a second to have any consideration. Have I heard a second yet? In the absence of a second, that motion will die for want of a second. Commissioners, do either of you have a motion?
I would move to appoint Dave Bridenstine.
Second.
We have a motion and second. Is there any discussion? No. Therefore, all in favor, why don't we do a roll call on that?
Commissioner Creighton?
Yes.
Commissioner Burnaby?
No.
Commissioner Regular?
Yes.
Motion passes.
That is the only matter of business coming to it. This, by the way, this action does require the filing of an application to employ counsel pursuant to revised code 305.14, and it requires the signing of an order by a judge of the Common Pleas Court. And as soon as we conclude this, if it's at all possible, Grant, I'd ask that you get everything signed and filed, and that we process this as quickly as possible, because to my understanding, the Board of Elections has been served with the public service, the legal service of the complaint, and therefore the time is running with regard to response to this. David, have an enjoyable weekend.
Yes.
That concludes today's meeting. I would entertain a motion to adjourn.
So moved.
Second.